Hey guys, I just wanted to point out some church news. The church is filing an amicus brief in a Supreme Court case. Now, this isn't the first time they've done this. I looked this up and it looks like they actually did this back in 2024 in a similar case. But basically, they recently filed this amicus curiae brief in two consolidated Supreme Court cases involving the petitioners, Governor Bradley Little of Idaho and the state of West Virginia. The brief was filed by the Church of Jesus Christ of Latter-day Saints, the National Association of Evangelicals, the Ethics and Religious Liberty Commission of the Southern Baptist Convention, the Coalition for Jewish Values, and the Jewish Coalition for Religious Liberty. So several religious organizations are getting together on this. These groups, they all share a belief in the inseparability of biological sex and gender. And they're all committed to religious freedom. So they teamed up, filed this brief to support these petitioners who have these Supreme Court arguments against the idea of granting transgender status heightened scrutiny under the Equal Protection Clause. The brief argues that making transgender status a quasi-suspect class would harm religious freedom by creating legal and social problems for religious organizations and people of faith. And here's a little bit of a breakdown. So argument one is focused on these unsettling federal rights and chilling religious freedom. So the brief contends that the elevating transgender status idea would create a conflict with existing religious freedom protections, such as the Religious Freedom Restoration Act and the First Amendment's Free Exercise Clause. It states that this would create legal uncertainty, forcing religious organizations to guess whether their rights would be protected in court. The brief claims this uncertainty would chill the exercise of religion by exposing religious people and institutions to fines and lawsuits simply for living their faith. It highlights potential conflicts in areas of religious employment, public accommodations, public funding, as well as parental rights. And then the second argument, it focuses on this like stigmatization of religious organizations as a result of this granting of a status. So the brief is arguing that granting heightened protection to transgender status would stigmatize religious people and institutions whose beliefs hold that sex and gender are divinely created and inseparable. It suggests that this legal change would brand those who hold traditional religious beliefs as bigots, comparing the situation to past Supreme Court cases on same-sex marriage. And we all know that was happening back in 2015 was when we got that Supreme Court ruling that federalized same-sex marriage. And so this is similar to those cases according to this argument. So the brief asserts that the Constitution protects religious freedom and that no official can prescribe what shall be orthodox in religion. What is a quasi-suspect class? In the context of U.S. constitutional law, a quasi-suspect class is a group of people who are protected from discrimination by the Equal Protection Clause of the 14th Amendment. Laws that discriminate against these groups are subject to a form of judicial review called heightened scrutiny, which is more difficult to pass than the standard review. The brief's authors are concerned that if transgender status is designated as quasi-suspect class, it would empower courts to override religious freedom protections, which are also often determined through a balancing test. So this is the docket here, a little photo of that. And then there was one other case back in 2024 of October that was similar. Last year, the Church of Jesus Christ of Latter-day Saints had submitted an amicus brief in a different Supreme Court case arguing against public school policies that teach young children about same-sex attraction and gender identity. asserting these policies infringe on parental rights under the Free Exercise Clause. The brief filed in October 2024 argues the school's interests in such education are not compelling and that it violates constitutional rights. This is consistent with the church's long-held doctrinal stance articulated in documents like the Family, A Proclamation to the World. And as you know, or I'm sure you've read, that we recently had the 30th anniversary of the Family Proclamation earlier this week, just a few days ago, in September of 2025. And so this is coming up, this new case is coming up around the same time, and you can see here there was a similar case back in October of last year. So this is something the church has been doing for a while now. I mean, going back even decades ago when the church created the Family Proclamation, the church was already involved at that point in legal opinions or filing amicus briefs and expressing an opinion to support their views on religious freedom. And so this isn't really anything new that the church is doing. It's just a new type of case. And it also is centered on the doctrine of the family. So it's just something interesting, maybe something to note that's going on right now. And anyway, some key points on the amicus brief that was filed a year ago is that it had emphasized that public schools should not teach young children about topics related to gender identity or same-sex attraction, framing this as an infringement on the constitutional rights of parents to direct their children's religious and moral upbringing. The church has always been a strong supporter of religious freedom and liberty, and this latest case is one of many. Anyway, let me know your thoughts in the comments. Do you think that this is something the church should be involved in? And if not, let us know. If so, let us know what your thoughts are. Also, do you see this as a sign of the times, that we are having more and more of these as the decades go by that are centered on the Family Proclamation? Was the Family Proclamation prophetic? Let us know your thoughts in the comments. That's all for this one.